This is Boomer Life on CL 650.
Hey, and welcome back to The Law Show on CL 650. We're talking about personal injury, really revolving around car accidents. And from McQuarrieHunterLLP, we have Kevin Hyde, partner, and Neil Mulholland, associate counsel. And we're talking about the different parts of the insurance that you get when you buy ICBC insurance. And we're mandated in the province to have a minimum amount of coverage with the provincial insurer. So we talked about underinsured Motorist protection. I'm trying to think motor vehicle, but it's motorist protection. And then the next one is Part 7, and there are Part 7 benefits. And this comes with everybody's policy, and a lot of people aren't aware of this. So maybe explain what Part 7 is.
Well, basically what Part 7 refers to is a segment of the regulations under the Insurance Vehicle Act. And these are benefits that are sometimes referred to as add-on benefits or no-fault benefits, although that last term can result in some confusion. But basically what it means is that anybody involved in a motor vehicle accident is entitled to those Part 7 benefits, whether they are at fault for the accident or they're not at fault or nobody's at fault, doesn't make any difference.
And ICBC adjusters often use that to their benefit, because I've had clients come in and say, well, I wasn't going to come and see you because the adjuster's been so nice. They've been paying for my treatment. They've been offering me TTDs, which tops up my wages when I've been off of work, and now I'm starting to feel a bit better. So, and they've been so kind. They've offered me a couple $1,000s as well.
Yeah.
Well, no, that adjuster owes you that whether you're at fault for the accident or not, and that's different than your tort claim.
So they're basically giving you what you've paid for.
Exactly.
Yeah. Whether you're at fault or not, and people don't understand that.
So let me, from hosting this show in the past, one way to describe it is that these are benefits that kick in to make you, to help you feel better, get, if you're going to massage therapist or what have you, until your settlement is finalized, right?
The best way to think of them is as kind of a safety net.
Right.
They exist to provide a minimal level of income support and to provide for basic treatment costs and rehabilitation costs and so forth. But they generally apply when nothing else does. And one of the topics that people often ask about is, well, how does my extended health coverage relate to these Part 7 benefits? Well, in essence, what it's all about is that your extended health coverage is what we call primary insurance. That's where you go first. Part 7 benefits are what are known as secondary insurance. So they're supposed to kick in when nothing else is available. So, for example, if you're off work and your employer provides a sick pay type plan or a short-term disability plan, well, that's where you're supposed to go first to recoup your lost income. ICBC will pay you up to $300 a week in what are called TTDs, or total temporary disability benefits. On top of that, private disability coverage in appropriate cases.
Does ICBC know what it costs to live in Vancouver? $300 isn't going to give you much.
And it's interesting you brought that up. It's been the same level since '83.
Yeah.
In '83, you could probably rent an apartment for a great deal cheaper than you can now.
Yes, absolutely.
They've ignored inflation completely.
So the fact is, Part 7 benefits, they apply to you, as we said, regardless of who caused the accident. And in a significant case, a major loss or catastrophic type case, those benefits would include a lot of rehabilitation services, occupational therapy services, and so forth. It's quite proactive. Used to be handled in-house at ICBC by their rehabilitation department, which unfortunately has been discontinued, and the same services are now generally run by private occupational therapists and benefit coordinators, disability coordinators, and so on. There is a lifetime cap on Part 7 benefits of $150,000 per incident. So somebody who is catastrophically injured in an accident has up to $150,000 worth of benefits under that Part 7 section. And as I say, that is independent of the claim they may have against the driver that caused the accident.
But a lot of times people are accessing this treatment because sometimes you're dealing with files that are, settled in 6 months, and it's for soft tissue injury, what have you. It's not a catastrophic case, but they're basically getting what they need before it settles.
That's right.
So that's how it works for a lot of people, right?
It works to replace disability insurance and extended health insurance for people who don't have it.
Sure.
And it supplements those coverages for people that do.
Right.
Now, in many cases, what will end up happening is you will have certain costs covered by Part 7, for example, physiotherapy or massage therapy or chiropractic. And those same costs are also covered under somebody's extended health plan. So as we said earlier, because the extended health plan is considered the primary insurance, that is where you submit those receipts for reimbursement first. But in some cases, the extended health plan will want to get reimbursed themselves at the end of the claim. And so again, one of the sort of the side benefits to retaining counsel to represent you in an ICBC case is that when it comes time to negotiating that reimbursement with your insurance company, we're generally able to negotiate that amount.
So the liability coverage, the liability that you're going after to settle the claim is, say, pick $100,000. That'll come out of the person that used their insurance.
Exactly.
And then the amount of money that went to the massage and all that kind of stuff would come from the Part 7 coverage, right? Is what you're saying?
Or from the person's own private coverage if they have it.
Okay. So there are two pots of money, basically.
Yeah.
Right.
Now, the system is supposed to be set up to prevent double dipping. So in other words, if somebody pays you $1,000 towards your physio user fees through the tort coverage, the claim against the wrongdoer's own insurance, and you get that same coverage through your extended health plan, that would be, in essence, getting paid twice for the same loss. And so the reimbursement system, and there's different ways that it can be done, but the process is designed to prevent that sort of double dipping. So if you've gotten paid for the same loss on the wrongdoer's liability policy, you're supposed to reimburse that loss back to your own extended health policy.
Now, back to Kevin's point is that does ICBC bring this forth voluntarily? Or did they not give you the whole lay of the land?
Well, that's a complicated question, but basically what it comes down to is ICBC will usually tell people that they're entitled to a certain number of physiotherapy visits, a certain number of massage therapy or chiropractic visits.
But you're saying it's up to $150,000.
And they won't tell you that.
So what do they say? You had 12 visits or something like that?
Typically it's a dozen visits, and if you need more, they require a doctor's note.
You have to get a doctor's note at all times, so you always have to get a referral to go back for the treatment, and they should be covering it at that time. But often
is that the case? Is that for everybody? You have to keep going back to the doctor to get a note?
Yeah, that's the proper way to do it. But often what is the case is that an adjuster says, you know what, we don't want to pay you anymore, and this is with unrepresented people usually. We've gone to 24 physios now, and I got a doctor's note here, but it's clearly not working. Well, the adjuster's out of line to be able to do that, and a lawyer will put them in their place pretty quickly.
And have you had that happen?
I've had that happen. I've seen it happen on both ends where they're saying either you're not getting enough treatment or you're getting too much treatment, depending on what benefits the ICBC at that point of time. You can never really win with them, but the reality is you have a duty to mitigate. As the person injured in the accident, you have a duty to follow whatever treatment is being recommended by whoever's treating you, the doctor, in most cases the GP.
And they will say, oh, no, we disagree with the doctor?
They will, in some cases, yeah.
In some cases they will, especially if you don't have a lawyer there and the people don't know any better and they stop getting treatment, their injuries go on.
Or in many cases where they send you to their own doctor for a medical evaluation, and he concludes that you don't need any more physio or you don't need any more chiropractic. And Part 7 is typically not much of a dispute when it comes to those sort of typical run-of-the-mill treatments like physiotherapy and so forth. It's where you have clients who need treatment a little out of the ordinary or a little more involved that you sometimes get into a bit of a debate. For example, kinesiology, active rehabilitation type therapies. Oftentimes, it'll be a situation where the family doctor is saying, yes, it's time to try this. And in some cases, the adjuster is saying, well, I don't really feel like paying for that. I'd rather continue to pay the much lower cost for physio, for example. Other times, there may be a particular type of treatment that this particular client needs for perhaps a little more unusual injury. And the adjuster may not have encountered a situation like that before and not really know what to do with it, so they just sort of sit on it. And where we come in that process is we can basically start a separate parallel legal action where we are suing ICBC under the Part 7 benefits, saying basically,
you're withholding, right?
Yeah. My client has paid for this coverage, and you're not
honoring the agreement, right?
In essence, yeah. That's no different from, for example, if you have a fire at your house and they won't pay for that loss, well, you'd likely hire a lawyer to deal with that. And so In extreme cases, it can be necessary to go to court and get an order that ICBC cover a certain treatment under Part 7. It doesn't happen all that often, but again, it's one of those situations where when it does happen, it's usually where the treatment is very costly and or somewhat experimental.
Now, one of the things that I've found interesting is that when you hire a firm like Macquarie or, you get a lawyer involved, the communication with ICBC ends. And also one of the things I find interesting is that, the ICBC says, well, you're 90% at fault. And most people would say, oh, okay, I guess I'm 90% at fault. But that's not the case. When you have a lawyer involved, that determination is not final, is it?
No.
And talk a little bit about the fact that you are now speaking to ICBC, not the client, right?
Yeah, exactly. I've had a client before they retained me that didn't even bring up a subsequent accident because they just assumed they were at fault because ICBC held them at fault. And once I actually discovered this, I said, oh, well, tell me what happened. Clearly, this was a case where at the very best for ICBC's defendant in this case, it was a 50-50 split. If not, my client wasn't at fault at all. And people make that assumption that ICBC's internal determination process on liability is the absolute. That's not the case. It doesn't matter what ICBC determines. It matters what a judge said. And oftentimes when liability is at dispute, you can bring forward a liability-only trial. You can split that off from the damages, determine liability only, and then proceed accordingly. So if it is determined to be a 50-50 split, you can still proceed with your tort claim in that regards and recover 50% of what that award would have been. And the
other thing is taking the pressure off the phone calls and the communication, right?
Exactly. Once you retain us, I think I said on a previous show that for a lot of people, it's not necessarily that we're going to go to bat and get them properly, fairly compensated for what they're entitled to under their insurance policy. It's that they don't have to deal with ICBC calling them all the time and whatnot. And they have to go through us. Once we're on board, once we send that letter of representation, the adjuster cannot contact our client directly with regards to their tort claim, asking about their injuries, asking them to sign releases to get their documents. And what we do is we revoke all releases that were signed at that point to get the documents, and everything goes through us. And we also protect your privacy in that we redact anything that's unrelated to this accident. It's really none of ICBC's business. So we protect your privacy as well.
All right, quick break. When we come back, we're going to talk about, how many cases actually go to trial and when you should settle, maybe not go to trial and how that works. On The Law Show, next on CL 650.
Celebrating the baby boomer lifestyle. This is Boomer Life on CL 650.